Now, this deals with an entirely prosaic issue that comes up all the time, constantly. And the appellate division says in the decision, we are sick and tired of seeing this come before us. We're tired of it. That's all we can stand. We can't stand no more. They actually say this in the opinion. They actually quote Popeye saying that. All right. It's unusual. They usually don't quote Popeye in a public decision. I think they said there's been 7 unpublished decisions dealing with this legal issue, and we're sick of it. Okay. What is the issue?
Operation.
Sleeping in the car with the engine on. Okay. And the appellate division says, listen, dudes and dudettes, this is operation. If the defense is asleep in the car and the engine is running, we consider that to be operation. That is operation. It constitutes operation. So that's our ruling. Stop wasting our time bringing this all up, okay? Now, let's think about this a second, okay? Because I'm not taking no for an answer. I don't care what that appellate division panel says. They frame it as the guy's asleep in the car with the engine running. Good, that's fine. I can live with that. 2 issues coming up. Number 1, what happens if the guy's asleep in the car and the engine is not running? See, they don't talk about that, and they don't exclude that. They don't consider that necessarily to be operation. So if you have a guy sleeping in the car, especially if the keys are not in the ignition, but if the car is stopped and turned off, you've got to distinguish that from Thompson, because Thompson over and over and over again throws the proviso in there, asleep with the engine running. If the engine is not running, you've got to bring that up as an affirmative defense on operation. It's extremely important. I wouldn't have you write this stuff down unless I deemed it to be of that level of importance for you guys to know and think about when you're analyzing these cases. Number 2, and they don't talk about this either, irrespective of whether the engine is running or not, if the guy's asleep in the car and he has a bottle of Captain Morgan next to him, which is open and partially consumed, now you're in business, because now you have evidence of a potential glove box defense. Remember, this Tishio case has it's a 2-edged sword. You know, in the appellate division, which was adopted by the Supreme Court in 1987, they talk about the necessity of the defendant not consuming any alcohol between the time of operation and the time that he takes the test. Okay? Well, how's the state going to do that when they find the defendant passed out in the car, engine running, and significant evidence of alcohol consumption between the time the vehicle stopped and the time they're going to take the test? When was the last time you had something to drink? You see what I'm saying? Now, this defense becomes all the more powerful if the engine is not running. But what I'm suggesting to all of you is that if you're going to raise a glove box defense, you got to have persuasive, powerful, circumstantial proof of recent consumption of alcohol in the form of open containers of alcohol beverages, okay? It may be Captain Morgan, it may be a 6-pack, it may be all kinds of bottles of beer, it could be anything, all right? But you've got to have that type of evidence in order to bring up the affirmative defense of the glove box defense, all right?